Imagine a tax planning structure designed to eliminate £10 million in annual non-recoverable VAT, plus capture a one-off £21 million cash benefit right before year-end.
According to Barclays evidence, those were the anticipated commercial VAT consequences of grouping their US service entity with their UK operations. Sounds like a CFO's dream scenario, right? Well, for Barclays, that planning opportunity turned into a multi-million-pound legal defeat. On June 8, 2026, the UK Upper Tribunal handed down its decision in Barclays Services Corporation versus HMRC.
It is one of the most significant UK VAT grouping decisions in recent years, providing vital guidance on how HMRC and the courts evaluate overseas companies seeking UK VAT grouping. Although this case concerns one multinational bank, the principles extend far beyond financial services. Any overseas group seeking UK VAT grouping through a branch should take notice.
If you think a basic branch registration with Companies House is enough to secure a UK VAT group, think again. In this video, we're unpacking where Barclays' structure fell short, how HMRC blocked them, and what this means for your group service entities. Let's dive in. To understand this case, we have to look at how UK VAT grouping operates under Section 43A of the Value Added Tax Act 1994. Normally, when an overseas entity provides services to a UK company, the UK business accounts for VAT under the reverse charge rules. If that UK company makes VAT-exempt supplies, as financial institutions routinely do, it cannot recover that VAT. It becomes a permanent sticking cash cost.
However, the UK operates a permissive whole legal entity approach. Under UK law, if a non-UK company establishes a genuine fixed establishment, such as a branch in the UK, the entire overseas legal entity can join the UK VAT group.
Once grouped, intra-group service charges are completely disregarded for VAT purposes. No VAT, no reverse charge. Barclays sought to use this rule to group its US service company, Barclays Services Corporation, via a newly registered UK branch. The potential commercial benefit included eliminating a sticking VAT charge on card services, saving £10 million annually on US recharges, and securing a £21 million cash benefit. On December 1st, 2017, they filed their application. That exact date became the focal point of the litigation. To qualify for grouping, the UK branch had to be a genuine fixed establishment on the specific day of the application. December 1st, 2017. The tribunal considered whether the branch exercised control over the relevant human and technical resources comparable to ownership. When HMRC audited the branch as of December 1st, they found what the upper tribunal itself explicitly described as a skeletal presence. On December 1st, 2017, the branch had 0 active employees. Contracts signed in January 2018 were backdated. The tribunal held that later documentation cannot create legal rights and obligations that did not exist on the application date. The proposed head of branch was legally employed by a different UK entity and reported to management in India, not the US service company. The branch claimed space at Radbroke Hall in Cheshire, but had no lease, no written agreement, and no formal occupancy rights. Practical desk access within a corporate group does not equal legal control. The branch's core job was monitoring intragroup agreements, yet on December 1st, personnel had no IT system access to perform that role. The lesson is straightforward. Incorporation creates a legal entity. It does not by itself create a fixed establishment for VAT purposes. Operational substance must exist on the exact day you apply. An arrangement that has not yet become operational cannot be grouped on expectation. Notice what HMRC did not do. They did not stop once they saw the Companies House registration. Instead, they asked much harder questions. Who actually employed the staff on that specific date? Who supervised them day to day? What IT systems could they credentials access on day one? What premises did the branch legally control, not just visit? What commercial work was the branch actually executing?
This case is a classic reminder of a principle we emphasize constantly. VAT follows commercial reality, not legal form or organizational charts. Beyond the fixed establishment test, the upper tribunal addressed HMRC's statutory power to refuse grouping.
The decision suggests that where the commercial evidence indicates that the branch has not yet become operational, HMRC's statutory revenue protection power may justify blocking an application. They confirmed that Parliament specifically legislated for this model, and the courts cannot rewrite statute through judicial interpretation.
This confirms the UK's principle remains intact. Following HMRC's Revenue and Customs Brief 7, 2025, Businesses may wish to review whether historical repayment opportunities remain.
So, what should CFOs, FDs, and tax directors take away from Barclays Services Corporation? First, operational substance must exist before you apply, not afterwards.
Second, every employment contract, office arrangement, and IT resource must be legally documented and under branch control on day one.
Third, assume HMRC will look past your corporate structure chart and examine what the branch was genuinely capable of doing on the application date. If your group operates overseas service companies with UK branches, now is the time to review whether those branches would withstand the same scrutiny Barclays faced. Waiting is almost certainly too late. If you found this breakdown valuable, make sure to like, subscribe, and share this with your finance team. Thanks for watching, and I'll see you in the next briefing.